The reason that I started this is I belong to a number of, let me tell you who I am for those who don't know me. My name is Harry Fine. I'm a paralegal licensed by the Law Society. I've been a paralegal since before paralegal, excuse me, regulation existed. And then when licensing occurred in 2008, I became a licensed paralegal. This is my website. And I don't do all that many files nowadays because I'm trying to slow down a bit. I had a grandchild this year, so I want to spend more time with my little 6-month-old grandchild. And but I take a few files here and there, but I do a lot of teaching. I do a lot of consulting. You can see from my website, there's a link here where you can click and sign up for a consultation. And also have a lot of education products for just letting people in, a lot of education products for landlords, for realtors, for paralegals to understand how the RTA works. If you're in trouble with a tenancy, you'll always do better with a paralegal than without. But, paralegals aren't free. There's an expense to them. And sometimes people don't want to spend that $1,500 or whatever the cost may be. So they want to do it on their own. But if you do it on your own and it takes a year to get to the board, and you've done it on your own and you haven't been perfect, you lose.
Yeah.
So the alternative, and I did this a couple of years ago, is to create on-demand products for everything, whether it's rent control, starting a tenancy, evicting for various things, whether it's for conduct or for rent or for purchasers intended use, etc. So if you have any interest, you can take a look at my website, but that's not what I'm going to focus on tonight. I'm going to focus on a PowerPoint that I just whipped up today and talk about. So I was on Maria's website and people were saying, oh no, it's less than 28 days. So
or more.
It's short term or it's more than 28 days. So, the RTA is going to apply. And that's just not true. And it's confusing. So I wanted to stop the confusion. And, I just said, because Maria runs a number of good groups and we're friends. And I suggested to her, look, why don't I do this freebie? And because, most of my webinars are paid. So why don't I do this freebie and talk about some of these issues so that people who are thinking of getting into short-term rental understand what short-term versus long-term is. And conversely, people that are thinking of getting into long-term rental understand the difference and understand the distinction between the two of them. So you should all now see the PowerPoint in front of you. You're all investors or landlords or realtors, so I think you know these things, but LTB means Landlord Tenant Board, which is the sort of a court-like agency that now, through video, does hearings all across Ontario for people that have disputes, landlords and tenants, and they try to resolve them as best they can. I'm fairly critical of the Landlord Tenant Board, as those of you who know me know. I'm particularly critical lately because this whole process of video hearings is just like fast. And it's very difficult to really properly examine witnesses and present evidence and things like that. I understand they can't do in-person hearings, but you've still got to have a degree of fairness and a chance for people to tell their story. And sometimes lately that's not happening. But anyways, that's what the Landlord Tenant Board is. It has exclusive jurisdiction to deal with residential, nothing to do with commercial, residential landlord and tenant in Ontario. And of course, if I say the Act, I mean the Residential Tenancies Act. That is the law that governs residential landlords and tenancy disputes in Ontario. It's funny, I have, just a quick aside here. I have a friend in British Columbia and his daughter's received a notice to be evicted in a little city of White Rock, which is a suburb of Vancouver. And she got a notice from her landlord and she's all upset. And I don't do work in British Columbia, but I told her I would help her. So I went and I read through the British Columbia Residential Tenancies Act and some of their cases about evictions for landlord's use and their rules of procedure, stuff like that. Because I'm going to appear with her, on Zoom for their hearing. And I know a little about the British Columbia RTA. As it happens, it's called the RTA, the Residential Tenancies Act. But it's, change my views here. But I thought, I better read through those sections, particularly pertaining to notices of termination and notices of termination for landlord's use. And I was sort of shocked at how much less procedural it was. And let me give you one great example. So many landlords lose in Ontario. They go to the board, they have a great case, but they lose because they've said that a termination date is April 31st, which doesn't exist. Mm-hmm. Or April 15th instead of 14th, where a tenancy started on the 15th. Where under the BC RTA, there's a provision that says that if a landlord gives a notice that is too short, it's deemed to be amended to the day that is the proper day that it would have been, had they given proper notice. Or if a landlord simply gives a notice for a date that doesn't make sense, like April 31st, it's automatically amended. In Ontario, thousands and thousands of those types of mistakes get dismissed. Landlords' applications for evictions get dismissed a year because the Ontario RTA is so damn procedural.
Mm-hmm. Yeah.
And it ends up creating more cases, because if tenants know there's a million little tricky ways to dispute an application, that encourages bad behavior. I'm a big believer that if you encourage bad behavior, that's what you're going to get. Incentives determine behavior. So anyways, that was just quite sort of shocking to me how different it was. We're going to talk about what it means to be exempt from the RTA and what it means to be exempt in a short-term tenancy, which is, let's say, an Airbnb, versus exempt from a long-term rental, exempt from the RTA, because you're in one of those categories that is exempt from the RTA. I live in Toronto and I'm more familiar with Toronto rules. Every municipality is going to end up having their own rules about STRs. I know that Ottawa's thinking about it. I know Niagara Falls was, Marie, I don't know if they still are. All over Ontario, they're looking at what Toronto's just done. So every city is different, and you'll have to figure out what your local rules are in terms of STRs and whether they're going to regulate it. Hopefully, for your sake, they don't regulate it, because STRs are a great way to make money and get an investment that has a good rate of return and good security without having to worry about the damned Residential Tenancies Act.
I agree, Harry. I agree.
I know you're in favor of that.
Well, of course, but you know what, like myself, I have a bed and breakfast and cottage rental in the town of Niagara-on-the-Lake, and we've always had to be licensed. But it was very fair how it was done. Now in Niagara Falls, it's not being fair about it,
Yeah.
So every single city is different. So I'm glad you brought that up, because that's what everyone should know going into the business. If you're going to be going to the short-term rental business, you should be checking with City Hall, the bylaw office, and just find out if you're even allowed to do short-term rental.
Okay. And if you don't understand reading bylaws and stuff like that, you can belong to a group like Maria's, or hire a lawyer, or hire a paralegal.
Yeah.
We're going to talk about the gap between municipal bylaws and the RTA, how actually it left some funny spaces. Yeah. We're going to talk about this whole 28-day exemption myth, because it doesn't really exist at all. We're going to talk about, okay, so what do you do if I want to evict a tenant and he's a tenant who's governed by the RTA? What do I want to do if I want to evict a tenant who's a non-RTA long-term tenant? And what do I do if a tenant doesn't want to leave, if he's a short-term, I don't want to call them a tenant, a short-term guest,
Yes.
And you need to get rid of them. And I want to talk about the importance, if you're doing STR, of using a platform of some sort, so that at the end of the day, you'll be able to prove your intentions to a judge that you were actually doing it as a short-term rental and not trying to do it as a traditional long-term tenancy. The RTA, the most interesting and probably powerful section of the RTA is Section 3. And Section 3 sub 1 says that the RTA applies to rental units in residential complexes despite any waiver or agreement to the contrary. So what that means is that I can't rent to somebody as a long-term tenant but have a written agreement that it's a short-term tenancy. I mean, we can do that, but it doesn't matter. What matters is what the RTA says. The RTA applies despite any agreements that you may have or any ways you want to waive your rights under the RTA to the contrary. You can't contract out of the RTA any more than you can contract out of the Employment Standards Act and agree to pay somebody less than minimum wage. So that's important. You can't agree that something is a short-term tenancy and then rely on that. So are you covered by the RTA? Well, nobody wants to be governed by the RTA because the RTA is tough. And it's particularly tough when it takes 6 months or a year to evict a tenant. It used to be when I was a member of the Landlord Tenant Board, I was an adjudicator there. It used to be we'd get things heard before us in a month.
Mm-hmm. Yes.
And a month made sense because people have a 1 month rent deposit. So, if they weren't paying, at least landlords had some backup they could rely on. But nowadays, I have colleagues who have filed applications back in March who don't have hearings yet. That is pre-COVID, when it closed down for 5 months. Lots of people who filed in August without hearing dates yet. Almost no hearing dates being issued in January, which we don't understand.
Mm-hmm.
And with the provincial lockdown that's just happened and the pressure on Doug Ford from tenant advocacy groups to ban COVID evictions again, because remember they did from March to August, I would think that you're going to see another banning of evictions for those even who have eviction orders in their hands. So it's going to be interesting, and you certainly don't want to have the RTA apply. But if it does, it does, and you can't control that. So some tenancies are fully exempt from the RTA. How do you become fully exempt from the RTA? Well, you have to be in one of those categories in Section 5 of the RTA. And if you're not, then you're not exempt. I mean, you can't make it up. You can't decide on your own. I'm showing you now the Residential Tenancies. I'm showing you now the Residential Tenancies Act. And if we go to Section 5, and you can see it here it says exemptions under the Act. These are the only things that will allow someone not to be a residential tenancy where the RTA applies. Traveling or vacationing public, for short term, temporary accommodation. That's the one so many Airbnbs and STRs rely on. Employed on a farm and you're living on the farm. If you're in jail, obviously the RTA does not apply to that relationship. Emergency shelters, educational institutions like residences. The biggest, living accommodations where a tenant's required to share a kitchen or a bathroom with the landlord or a member of the landlord's family. So those are the only ways you can be exempt from the RTA. Simply saying it's a short-term rental doesn't matter, because if it doesn't get exempted by one of those Section 5 exemptions in the RTA applies, even if it's a short-term rental. Now, if it's a short-term rental, it probably doesn't apply, but not because it's a short-term rental, only because it's got to fit into an RTA category. Examples of RTA exemptions are the sharing of a kitchen or a washroom, a tenancy that's predominantly commercial, temporary, intended for traveling or vacation public, vacation home, hotel, Airbnb, etc., bread and breakfast, certain types of educational institutions. And by the way, if you're running a rental that's a student rental, the RTA does apply. It's only actual university residences where the RTA might not apply. If you're in a place as a tenant receiving rehabilitative or therapeutic services, the RTA does not apply. So those tenancies are fully exempt from the RTA, the ones described in Section 5 of the RTA. And if they're fully exempt, what laws do cover them? Well, they're considered to be commercial tenancies. In other words, the law of contract will apply, your lease will matter. You will have the Occupiers Liability Act, which is an Ontario statute applying. The Human Rights Code applies. The Building Code applies. Lots of things apply. But if it relies on one of those Section 5 exemptions, then it is not a part of the RTA. It is strictly governed by contract, and it's considered a commercial tenancy. A lot of landlords who have non-RTA tenancies, so let's say they're sharing a kitchen or a bathroom with the tenant, or the tenant is sharing a kitchen or a bathroom with the landlord or a member of the landlord's family. That's the way the act is worded. Let's say that's the case. And you should see me now, as opposed to, sometimes sharing doesn't work as well as it should. Okay, so let's say you have a non-RTA long-term tenancy, because sharing a kitchen or bathroom or whatever. A lot of landlords think, hey, I don't need a lease. I can just kick them out. But you can't. And the truth is, if you have a non-RTA long-term tenancy, because they're sharing a kitchen or bathroom with you, you need a comprehensive lease covering everything. And the reason for that is if the RTA applies, the RTA covers most things. Now, you still need a lease and a good lease appendix. Some of you know, and I'm sure some of you out there have actually purchased my forms package, partly because it's got 29 great forms, but partly because the lease appendix attached to the standard government lease is the best in the business, and it protects you in every way, shape, or form. But let's say you don't have an RTA tenancy, you have a tenancy to which the RTA doesn't apply. You need a full, proper lease because you haven't agreed to anything. And if you haven't agreed to anything, how are you going to agree on when I can tell you to go, where you can park, that you're paying for utilities, how you pay for utilities, that you can't plug in your Tesla, that you can't have overnight guests? I mean, all these things would be enforceable in a non-RTA tenancy. I can come in and inspect with 2 hours notice. I don't have to give you, all those things are possible in a non-RTA tenancy, but you've got to have a lease. And a lot of investor landlords where the act doesn't apply, they come to me for a good non-RTA lease that I help them draft, which is different from my standard lease appendix. But don't think just because the RTA does not apply that a lease is not necessary. It is actually more necessary, because if you don't have a lease, nothing in that relationship has been quantified. So,
good point. Good point, Harry. And I know that when my own members of all my associations, if they join my inner circle, they're able to get your lease at a discount price that you've offered, but it's only the inner circle. So I really appreciate that. I'm coming up with all the goodies that are going to be within my inner circle. And one of them is the lease. And I know you have the most comprehensive and best lease there is.
It's 29 documents, but the lease appendix that you use with the standard government lease is superb. I've spent, frankly, 20 years working on it, both when it used to be just a lease, or in 2018 when the government had their standard lease, and now, of course, as an appendix. So what's short-term, what's long-term? How does any municipal bylaws work vis-a-vis the RTA? I can't believe people are still coming in. We have 77 people here.
That's good. Well, they're very interested. I know that for a fact.
Oh, absolutely. So let's talk about the City of Toronto. City of Toronto, as you know, in 2018 was going to have a bylaw for short-term rentals. It got appealed to the Licensing Appeal Tribunal. Licensing Appeal Tribunal found that the city had every right to enact that bylaw. Then the LPAT decision got appealed to the Superior Court. That was dismissed. So the city is now enforcing their short-term rental bylaw, the City of Toronto. And starting January 1st, you've got to start submitting your tax to the city. So if you read the city bylaw, it says that for the purposes of short-term rental bylaw, short-term rental 28 days or less. So that's why a lot of people are getting confused about this whole 28-day thing. They think, oh, 28 days, that's some sort of cutoff. If it's more than 28 days, the RTA applies. Not true. Not true at all. But we're going to talk about that. The city says that short-term includes any form of short-term rental, not just Airbnb, VRBO. It can be through Kijiji. It can be an ad you placed in a supermarket, anywhere. If it's 28 days or less and follows the other rules, then it's a legal short-term tenancy in Toronto. However, the bylaw that the city has and that all the cities will have has nothing to do with the RTA. It's only for the purpose of enforcing the city bylaw, saying whether or not you need to pay the tax, whether or not you're allowed to have the short-term rental, etc. Nothing to do with the RTA. This is municipal. The RTA is provincial. So the zoning bylaw is now in force in Toronto. Just to keep those of you who don't know in the loop, here's some of the key ingredients of the new rules. Short-term rentals for your personal residence are permitted. And really, they're tough rules. Short-term rentals of the entire unit by the owner can't be for more than 180 nights a year. The person that receives the short-term rental money, that's you, the investor, has to pay a 4% municipal accommodation tax to the city starting January 1st of the new year. So that's new, of course. Short-term rental companies like Airbnb have to pay for a license and pay a fee, which is, I think, $5,000. Individuals who rent out their places have to apply for a registration number. The cost to apply, and it's on the City of Toronto website, is $50. And you tell them that it's your personal residence, and you swear to that, and you give them some documents, and you fill out a form, and they will give you a license number. Once you get that license number from the City of Toronto, that license number has to appear on all your ads. And the idea is that Airbnb, for instance, will not allow a City of Toronto ad without a license number. So I can see all these underground websites starting up that don't really care about whether or not you have a license number. So like everything else in life, money will find a way to flow around it.
For sure.
Zoning bylaws in force, the principal residence, because remember, you can only now rent out your principal residence. It's the place where you live, the address where you get your bills, where you pay your taxes and insurance on, where your ID on your driver's license is. Since you can only have one principal residence at a time, you can't legally in Toronto own more than one STR. That's shocking, because before there were people that owned 10, either in some of these Airbnb condos like the ice hotels, the ice towers, which were at 12 and 14 Iceboat Terrace, that were just full of the building's a disaster. And the building is now plummeting into maintenance issues and elevator issues. And of course, people can't sell their units because nobody wants them. And they're not allowed to rent under Airbnb anymore because it's not their principal residence. So these Airbnb hotels, people should have sold a year ago when it looked like Toronto was going to pass this. I suggested to people they sell a year ago, but many did not. So only one short-term rental per person. If your principal residence is a condominium, so let's say you do have a condo and you're out of the country for 6 months and you want to rent it on Airbnb, that would be allowed and that would be following the rules. But what if the condo in their declaration or rules says no short-term rentals less than 6 months? So that's fine. If you're going for 6 months on holiday, you could rent it out for 6 months and you'd be in compliance with the declaration of the condominium. But if you're going to try to rent something out for 2 months and the condo corp finds out that you got a rental unit that people are coming in every week or every month, you're going to get in trouble with the condominium corporation. And just let me give you an idea of how you can get into. If you run a condo in an Airbnb, if you run an Airbnb or a short-term rental of any sort in a condo that doesn't allow it in their declaration, they can take you to the Superior Court and force you to not rent it on a short-term rental basis. They can make you give up your business in effect. If you don't, they can take you to the Superior Court under the Condominiums Act for what's called a compliance order. They will show the judge the declaration They will show the judge the proof that you're running a short-term rental. They will get an order that you have to comply, an order from the Superior Court that you have to get rid of that STR. Now, the condominium corp's lawyer will probably bill the condo corp about $30,000 or $40,000 for that legal process. And under the Condo Act, the condominium will then take that $40,000 legal bill and attach it to your unit as a fee. And if you don't pay it, they can sell it. They can lien your unit and sell it and get their money back. So this is no joke here. If you think you're going to get away with renting in a condo that doesn't allow short-term rentals, you're not.
And that's the problem, Harry. I realized a couple years ago that when I saw that there was such an influx of short-term rentals, especially in Toronto in the condo market, that I knew I knew the city was going to come down hard on them. Also, I knew that the condo, the bylaw within the condo was going to come down hard on it. But who listens to good advice, right? Like, this is the problem, is people only see dollar signs. They don't see or even think that, hey, you know what? This is going to have an adverse effect. And which is exactly what's happening. It's pushback in all the major cities. The governments within the city centers are saying, no, we don't want this to keep on going, because they feel that if they cut back on the short-term rental supply, you could house more people.
Sure, that's their argument. They say in Toronto,
that's what they're saying.
10,000 units away from the short-term market. So it is what it is.
Yes, that's right.
It's now the law, and it's going to be enforced. Mm-hmm. So in Toronto, homeowners also can't, and this I thought was wrong, but this is what they did. I thought this was an overreach. Mm-hmm. You're not even allowed to live in the house and rent out your basement as an STR. Only full-time residents of those units can rent them out. So strangely enough, if you're renting out the basement to a long-term traditional RTA tenant, they're allowed to rent it out on Airbnb as long as they're principal residents, no more than 180 days a year, all that stuff. Give their tax money, their 4% to the city, etc. As I've said here in the next bullet point, even a short-term, even a tenant can rent out their unit on Airbnb as long as they follow the rules. That brings up another important point. If you're a landlord of a traditional long-term unit tenant, you've got to make sure that in your tenancy agreement, and again, this is in my lease addendum, I have a properly written clause, and you should consider using my lease addendum. You should have a lease addendum that clearly has a clause that says the tenants are not allowed to run a short-term rental business from their unit. Because if you don't have that in there, then tenants can say, hey, I'm going to start an STR operation from my regular rental unit. So be careful with proper wording.
Mm-hmm. Good point.
So if you have a second home, an investment property, a vacation rental in Toronto, and your principal residence is here, you are not allowed to rent them out as short-term rentals. You could still get Airbnb bookings. I mean, who wants to do it that way? You could change your profile on Airbnb and, say that it's now long-term, but you may as well do it without getting Airbnb involved. If you have a second property and you switch to long-term rentals, it's likely that the RTA is going to apply. And those Section 5 exemptions that I talked about would determine that. Is it something for the traveling or vacationing public? And here's where the gap comes into. Here's where the legislative gap comes into that is very confusing. And I don't even know that I have all the answers, because this is all new and the courts are going to have to figure it out. So follow me on this. Mm-hmm. If you have, people still coming in. if you have an STR, a short-term rental, so I have my one condo and it's a short-term rental and it's legal and I'm paying my tax and it's my principal residence because I'm out of the country 3 months a year. So that's fine. So I have my STR. What happens if I want to rent a place for 3 months to an out-of-town business executive who's coming in for 3 months? Does the RTA apply? Well, the city bylaw says it's not a legitimate STR, because the city bylaw says 28 days. So 1 to 28 days, city bylaw. Does the RTA apply? Probably not, because the RTA says in section 5, and I read you some of those exemptions, but I'm going to actually read from the Act again. Living accommodation provided by, whoops, wrong section. Living accommodation intended to be provided to the traveling or vacationing public occupied for a seasonal or temporary period in a hotel, motel, motor lodge, resort lodge, tourist camp, cottage or cabin establishment, campground, trailer park, tourist home, bed and breakfast, vacation establishment, or vacation home. So what it says is that if I have an occupancy that's intended to be seasonal or temporary, so in this case, temporary, in a vacation establishment for the traveling or vacationing public, in this case, traveling, it's a business person, so they're not vacationing, then section 5A says the RTA doesn't apply. That's great. I mean, that's really great, because you don't want the RTA to apply. Yet, the city of Toronto says that a short-term rental is 28 days or less. Well, what happens to those that are more than 28 days, but because they're exempt by section 5A, which is temporary accommodations, the RTA doesn't apply? I mean, it would seem to me, and this is going to have to get tested in court, that you could call it a long-term tenancy that's, you know, a 6-month tenancy that's exempt from the RTA by section 5A. And as long as you make sure that you keep it exempt from the RTA, the RTA can't bother you. Will the city say no? Will the city say no? That's short term. But the city doesn't talk about the RTA. They don't say it's either STR 28 or RTA. They just say our short-term bylaw 28 days or less. They've left this huge void. How do you make sure that if you do have, now I'm not talking STR now, if you are having a tenancy that's, let's say, 4 months or a month or 6 months or whatever, and it really is for the traveling or vacationing public for a temporary period, intended for a temporary period, how do you make sure that you don't end up having the tenant say, hey, I'm a long-term tenant, you can't evict me? Number one, have a lease drafted, a lease drafted that acknowledges that it's a short-term tenancy. Now, remember what I said at the beginning, section 3 says you can't just decide, you can't contract out of the act, but it's good to at least have a tenant's acknowledgement that the tenant is an employee of Philips Netherlands coming to Canada for a 6-month contract to reestablish a division. Then the lease itself would talk about rent being payable on a daily basis, that towels and soap and bedding supplies are provided, that there's a check-in procedure. There's all these things that make a hotel-like stay look and feel different from a traditional long-term tenancy. So is it absolutely an RTA tenancy just because it's 6 months? No, but you better be careful. It's got to be in that exemption, probably 5A, short-term, intended for vacation or traveling in a vacation home. And you're going to have to show in a properly written agreement that I or another paralegal can draft for you that it clearly is not a long-term tenancy. There's so much case law from the higher courts out there that describe the factors they think about when they determine whether or not it's a legitimate non-RTA tenancy. I've mentioned some of them, whether it's check-in procedure, how you pay. Do you remit HST? It's not a residential tenancy. Do you remit HST on it? Do you do the cleaning? Do you change the bed sheets, etc.? So going back to the PowerPoint, there is this legislative gap, and clearly it's a problem because there are lots of tenancies that are greater than 28 days, but where the RTA does not apply. If it's on the Airbnb system, a legitimate STR, and in other words, you're paying your tax, it's less than 180 days, it's in your principal residence, you have a registration number, and the tenant says, I'm not leaving. what do you legally do? And actually, this is what one of the posts was about on Maria's website. And people were saying, kick them out, lock the door, call the police. And every one of those suggestions were probably wrong, even though what you say may make sense, but it's wrong. Legally, yes, you could change the locks. They're a short-term tenant. You advise Airbnb, hopefully, and this is where people start getting into trouble. They get greedy. They put it on Airbnb for a week, and then the tenant says, guest says, I'd love to stay another week. And they say, okay, let's just do it privately.
No, don't do
Now
that.
you don't have the protection of Airbnb. Now you can't tell a judge that it's through Airbnb. So, I have an expression that I use for a lot of fact situations. You can't, the court will not let you suck and blow. You can't have it both ways. If it's a short-term rental, use a short-term rental agency.
Yeah.
Go through the complicated process of check-in and daily rents and sheets and towels and soaps and all that stuff, because you can't have it both ways. If you do it right, some judge is going to decide that the RTA applies. So legally, and I had lots of these over the COVID period where somebody'd move into a place and then have no place to go. And the guest doesn't want to leave, but they have to leave. So in some cases, the operator, the host, if they call them that, changed the locks. And the guest called the police and said, this is a long-term tenancy. The host said, look, here's my Airbnb agreement. Here's my Airbnb agreement. It's a short-term tenancy and it's over. The tenant says, no, that was for the first week.
Yeah.
And then we extended for a week. And then I told him I liked it so much. I liked it so much that he said, you know what? It's pretty slim pickings here. And the government said you can't do Airbnbs. This was the summer of 2020. I'll let you rent here long-term.
Yeah.
Landlord says, I never said that.
Mm-hmm.
We never had that conversation. The officer says, I'm leaving, thank you. Go to the LTB and let them figure it out. So it's very nice and cavalier of you to say, call the police or change the lock. Very nice and cavalier until you get fined large amounts.
Yeah.
It's not simple because the guest may say the RTA applies. And frankly, sometimes it does apply. Sometimes you didn't think it applied because you thought that you could just get away with doing this or that. But if you look at Section 5A, the Act does apply. Or sometimes it's because the tenant is simply scamming you. I had one in the summer that was just like this. Guy called me. He was a professional Airbnb operator with about 50 units in the ice towers. So he called me and said, Harry, I'm getting some people not willing to leave. So for a price, I wrote him a legal opinion that he could provide to the police to provide to their counsel. That is the police department's lawyers. And it was a thing of beauty that I wrote, really. But I'm sorry, it was. And the cops gave it to the council and they said, you know what? Just let the LTB decide. The LTB was closed from March 15th to August 4th. This was like in May. Now, in this particular case, it was fascinating. Woman moved in, Airbnb, 1 week. Landlord took her for a second week. They negotiated a price. The landlord sends her an email saying, I'm going to bring the cleaning crew in on Monday because that's the end of the second week. Thank you very much. And she says, what do you mean? I'm not leaving. Says, it's the end of the second week. She says, no. Remember you came in because the shower wasn't working and I called you and I told you it wasn't working and you came in and you didn't tell me you were, I swear this is true. And you didn't tell me you were coming in and I was naked when you came in. I was so embarrassed. But anyways, I got dressed, you fixed the shower. But then we had a long talk about long-term rental and you hummed and you hawed and you said, okay, I guess right now I'm not really allowed to do short-term after April 4th, I think it was. The woman scammed him into agreeing on a $1,200 a month, said, this was our agreement. It's a 1-year term, RTA tenancy at $1,200 a month.
Oh, wow.
So that's what can happen if you just think, I'm going to do some sort of informal thing here. You have to track everything because lots of people have been overstaying Airbnb stays and saying they had a deal. If you need to go to the landlord tenant board because you can. There's an application you can make to the LTB, either for an STR that won't leave, or a long-term tenant who's exempt because they share a kitchen and a bathroom who won't leave. You can file an application, to the landlord tenant board called an A1 application. It's an application to have the board determine whether the RTA applies.
And what's that going to take us 6 months to hear back?
Yeah, exactly. It takes 6 months to get a hearing.
What a useless, you know?
And guess what the tenant's paying during that 6 months? Once the tenant knows you're trying to evict them, zero.
Nothing. That's the problem that's been going on. That's why I've been telling all the members of the group, be very, very careful. There's so many scammers out there, Harry, now.
It's hard to protect yourself. If it takes 6 months to get a hearing, you could do everything right, and the tenant simply won't leave. At the end of the day, you're smarter to say to the tenant, here's $5,000, get the hell out, and pay them when they leave. Because if the unit's sitting empty for 5 months and you could get $2,000 a month for it, that's $10,000. So you've got to not deal with these emotionally. You've got to deal with these from a business perspective and say, how do I feel the least pain? Because the RTA is, and I hate to say it, and I'm not really supposed to say it as a paralegal, but I also don't want to lie to you. The RTA to some extent is a train wreck.
Yes, it is.
It doesn't mean it always will be. It doesn't mean it always was, but right now it is. And they're not there for you.
No.
If the RTA applies, how do you get rid of a tenant? Well, that's a whole different story. And you can, if you're looking to evict a tenant for whatever the grounds, I have webinars for that on my website that you can purchase very inexpensively. But obviously, if the tenant's done nothing wrong and you're not moving in personally, or you're not selling it to someone who's moving in personally, the tenant literally can stay there forever. So, 3 different categories. STR overstayed their welcome. Sure, try changing the locks, but it won't work. Long-term tenancy, but exempt from the RTA. Well, here's what they say to do. And I don't think I covered that. It's probably in the next slide. So if the RTA applies, you go to the LTB, you let the LTB decide. If you just decided to change the locks, you're in big trouble because you can be fined up to $50,000 plus compensation to the tenant. It can get very expensive. If you're in that category of short-term, of long-term tenancy, but the act doesn't apply because it's sharing of a kitchen or a bathroom. So if somebody's been in your place for a year, but the RTA does not apply, well, then it's a commercial tenancy. The common law applies. The lease wording is binding, which is why I said the lease is even more important in cases where the RTA does not apply. The case law says, and the common law says, that if somebody is in a lease that's month to month, and in this case, they're not protected by the RTA because they're sharing a kitchen and a bathroom with the landlord, you're supposed to give them a period of notice equivalent to the rental period. So in other words, 30 days notice. Give it to them in writing saying, here's your notice. You need to be out by the January the 17th. After that time, I will be changing the locks. And that is what is most often done. If you had a long-term non-RTA tenant, but they had lease term, you have to respect that term. Once you have an agreement with them, and you should have an agreement with them, then you have to abide by it. And when I do these leases for non-RTA long tenancies, I have 2 categories of termination. Termination at the end of the term with 1 month's notice by the landlord, written, or 1 month notice by the tenant. In other words, if things aren't working out after term, goodbye, I never want to see you again. But I put a second provision in saying, however, in cases where the tenant does the following, the landlord can give 10 days written notice that the tenant has to move out. And those are things obviously that are very contrary to the lease. It could be smoking in a non-smoking lease. It could be violence. It could be whatever it might be, starting a fire or using illegal drugs, whatever. Because when you're in a non-RTA tenancy, you can make the rules, but you can't make them after the fact.
Yeah.
you need a much better lease in a non-RTA tenancy. So in a non-RTA tenancy, the normal way is to give them notice equivalent to a rental period of 1 month and then change the locks. However, even that's not always so simple for two reasons. First of all, recently, and my paralegal colleagues have been arguing about this, and it's quite remarkable. A case went to the Superior Court in Ontario where a non-RTA residential tenant said to the court that the landlord shouldn't be able to just give him notice and change the locks, because if it's a non-RTA tenancy, it's simply a commercial agreement, even though it's for residential occupation, and all the rights under the Commercial Tenancies Act applied, including the right for the tenant to go to court and ask for relief from eviction. So you could actually be in the place for a non-RTA long-term tenancy where you and all your friends are always saying on Facebook, oh, you can just change the locks and kick him out. But if he takes you to court, that's not so certain. And finally, of course, the second reason why it's not so simple in a non-RTA long-term tenancy, because the tenant may say the RTA does apply. The tenant may say, hey, there is no kitchen or bathroom that I'm sharing. A lot of people misunderstand the kitchen bathroom exemption because it only applies if the landlord was there first. In other words, if the tenant was there and there was another tenant on the basement floor, and then the landlord's son moved into the basement, or the landlord moved in, and then the landlord says, well, now the RTA doesn't apply because you're sharing the kitchen. That doesn't work. You can't move yourself in order to get yourself out from under the RTA. And I remember a fascinating case I had once. It was in Mississauga LTB at least 10 years ago, where my client, the landlord, said, Harry, the act does not apply. He does not have his own kitchen and washroom. I said, you're sure? So we brought pictures to the hearing. The tenant comes to the hearing and he says, I have my own washroom. I have my own kitchen. I whisper to my client, I say, what's going on here? Did you lie to me? Does the tenant have their own kitchen or washroom or not? My client says, no, we only have the upstairs kitchen and he uses my washroom. So I said to the adjudicator, I said, Madam Chair, this is an impossible situation for you. You don't know which is true. The RTA allows an adjudicator to make an inspection of a property as part of a hearing. So it's almost lunchtime. I don't know if you have an afternoon block. Would you be willing to hold this down, meet at 1 o'clock after your lunch at the rental? We won't go inside. We'll wait outside. The tenant can't go inside. We wait for you, and then we go inside. She said, yes. I said to my client, you're sure he doesn't have his own? Anyways, we went inside. The tenant had just been lying. He shared a kitchen and a bathroom. But tenants, and this is an honest to God true story. So tenants will lie. Yeah. Tenants will lie. And just like landlords will lie. They will say, I have my own kitchen and washroom in the basement. So sometimes in those situations, landlords do call the police, whether it's for a short-term STR, non-RTA tenancy, or a long-term non-RTA tenancy. They call the police. And some people on the website say, oh, the police will take them out as a trespasser. Well, I'm not saying they've never done that. And in smaller communities where everybody knows everybody and the officer knows this guy, the officers say, come on, Bill, get the hell out of here. You're a bad character. Don't let me find you here again. And the tenant goes. But that's not the law. You're lucky if that happens. The cop will almost always say, landlord, I'm not dealing with it. Go to the landlord tenant board. I've even had cases where after a tenant's been evicted through the sheriff, through the landlord tenant board, that the tenant breaks in through a window and says, I'm a tenant, I live here. But in that case, the landlord has the writ of possession from the sheriff. And the landlord can show that to the sheriff and say, I want you to charge him with trespassing if he doesn't leave. And the sheriff indeed will get rid of the tenant. But don't you for a moment think that it's so easy,
Mhm.
because
No.
if you just lock the tenant out, he can file a lockout application and the board can order him back in. It just ain't so easy. So that's
Thank you so much.
complicated stuff about
Yes.
when the RTA applies, when it doesn't, and sort of this gap between, in Toronto's case, municipal bylaw and the RTA. It's complicated.
Mhm.
I'm happy to take, we said a half an hour, Maria. I'm happy to take questions till 7.
Yeah.
If,
You mean till 9?
no, sorry, I'm done. I say I've had too much to drink tonight. So,
You know what, Harry? Normally in the evenings, I have a little bit of glass of wine too, right? Because the days are pretty long. But you know, if you have to deal with the RT or LTB, have a glass of wine. You need it.
You want
I
the
mean,
before dinner scotch and the with dinner wine? I said, yeah.
you know, God bless you that you have so much knowledge that you can share it with us. But like everyone says, it's still complicated. And when you know sent me that message on Facebook Messenger, you said, Maria, it's complicated. It's one thing and it's another. Yes and no. That's what I said. Can you give me a straight answer? And you said, no, there is no straight answer. So I'm glad you came here. And you know, when I actually interviewed you for the first time in 2018.
Yeah.
When the new lease was coming, and I got in touch with you, and I did, you know, an interview at that time, and then you came down to St. Catharines and spoke to
St. Catharines, yeah.
Yeah.
Right in the canal, yeah.
the new lease. I remember that. So you've been, you know, you've been my go-to person for how many years now, right? 2 years now, going into 3. So I'm so happy to have you here. But yes, you'd have to open up their, you unmute them for anyone who has a questions, because there are
Somebody asked me a very good question, a very smart, well, a lot of people leave the questions in the chat, which somebody did.
Yes. Yes. Do you want me to read the questions in the chat to you,
I've
Harry?
got one that I read that goes to a question I had. Somebody said, okay, what if he's like working on a project? Does the act apply? Section 5H says, the act does not apply, and you have to read statute carefully, every word matters, to living accommodation that's located, so the guy lives inside a building or project, which is used at least in part for non-residential purposes, if the occupancy is conditional upon the occupant continuing to be an employee of or perform services related to the business. So that's sort of like a building superintendent where he's living inside, but it could be a construction project where he's living in a trailer on the site. But notice it says where the accommodation is conditional. So again, I get back to the importance of written documents. How do we know it's conditional? Because some good lawyer or paralegal has drafted an agreement that where the tenant acknowledges that his occupation of that unit is conditional upon him continuing to work for the owner of the project. Somebody asked me in an RTA lease, I just saw it, it was a new
month to month. Is it wiser for us to have month to month leases now rather than a year lease at a time?
Sure,
that has come up.
And it always was, but even more so today. If you have a lease with a lease term, during that term, you can't evict for any of the no fault reasons. That's for you or your family member moving in, a purchaser or a family member moving in. There's people logging in, it's a little late. For demolition or conversion of the property, conversion to non-residential, or for extensive renovation, in which case the tenant would have the right to move back in anyways. If you're in lease term, you can't do that. So some landlords said, well, term means if the tenant moves out early, I can get the money. No, you can't. This is not term as you would normally know it for, let's say, a commercial tenancy where there would be an obligation to pay the outstanding period subject to the landlord mitigating. The RTA is different. The landlord has an obligation to mitigate. If they can find another tenant, then you can't sue for that period. If they don't look for another tenant because they say, hey, the tenant's got 4 months left, then they can't win in court. And worse, Kathleen Wynne of the great Liberal government of 2018, 2018, when she became leader. 2017, she changed the RTA
Mhm.
a ridiculous provision, lots of them, but one of them said that if a tenant moves out without proper notice, so that is without finishing the lease term or without giving an N9 for, for 60 days notice. So if a tenant moves in without proper notice and the tenancy ends. Now, how does that happen? Well, if you give a notice of termination, like an N4 to the tenant, tenant says, use my last month's rent for December because I'm moving out. Landlord says, no, you're not. You never gave me notice. It's already December 18th or December 20th. You're not moving out. Here's an N4 for December's rent. Well, once you give that tenant the N4 or any other notice, and then the tenant moves out, the tenant's obligation to pay rent ends, no matter how much lease term ends. And then you get the problem of, and I apologize to realtors who are on this site, realtors who blindly follow the Rta clause wording, particularly the one that says the tenant may, within 60 days prior to the end of the term, if the lease is in good standing, give the landlord notice to renew for an additional year's term. Now that was written by lawyers for, I guess for, not for RICO, I suppose for Rta. And it's so badly written, it doesn't say that they only can do that once. It doesn't say they shall have no further rights of renewal. So I have had very sad files where the landlord wanted, in one case I remember in North York, her son to move back in to go to university because the son, they'd moved back and he was 19, he wanted to go to university, she wanted her condo back, but the landlord had rented out the condo using a realtor who used that clause. They gave the son an N12 notice. The son said, I'm not moving. They filed an L2 application. They went to the landlord tenant board and the adjudicator said, no. Adjudicator said, he's giving you notice every year that he's going to renew term. I'm looking at this clause in your lease that says the tenant has a right, if his tenancy is in good standing, within 30 days prior to the end of the term to renew his lease. He's done that every year. So how long can that tenant stay for? For
Ever.
I mean, for your lifetime.
It's scary.
So, lease term sucks. It is now 9 o'clock, not 7. So I'm done for tonight. I want to thank Maria for inviting me.
Thank you, Harry.
If you're looking for more information, look at my videos, or if you want a consultation, I'm happy to do that. And just saying, be careful. It's a business, know the RTA. If you don't know it, your tenant is going to eat you up alive because your tenants often know it better than you do. And you know what really bothers me, and I know Maria feels the same way, these landlords who say, I've got a professional tenant. The question is, why aren't you a professional landlord? You're the one.
Take care now. God bless. And you know what? Join up for my, I have my mastermind that's coming up. So you're welcome to join at any time. Please do come and join us. And I'm going to be sharing Harry's video. I hope everything worked out for us. Take care, Harry. Bye-bye. All the best. God bless you all. Bye, everyone. Love you all.
Bye-bye.